My dear friends, I am Sethuram from Nivedita Academy. Today's my topic is about vicarious liability. It is in law of tort. The students of CLAT examination should know about this very well. Generally, a person who does something wrong, full act, is liable for the acts done by him. But in certain cases, even he does not do anything wrong, but the acts of other persons, wrong acts of other persons, because of the other person's wrongful acts, this person is also liable. What is that one? So that kind of liability is called vicarious liability. This happens in situations like the relationship between principal and agent, partners in a partnership firm, employer and employee. When any one of the people does any harm, the owner is also liable for the act done by the other person. Suppose the agent of a dealership business, the distributors, dealers, agents, all are involved there. Any of the agent does something wrong, the owner of the business also is liable for that. So he will be taken as accused number one. The second only the person who did wrong, that person. Suppose it is a partnership firm, any one of the partner does something wrong, the whole firm is liable. Any one of the partner has got some money from the third person, for example. So in that case, the person who is affected by the wrongdoing of the partner, he can sue against the whole firm. The whole firm is liable for that. Then the firm can get that amount from the partner. He would have deposited some money in the firm, that can be taken away by the firm, or the firm can sue the other partner also. He can relieve him from the business firm, like that. Just like that, employer-employee relationship. For example, a driver, he drives a car, something happens, he did something wrong. In that case, the person who is affected will sue the owner also in the court of law. The court also takes that owner only as a first party and the driver as a second party, and it directs the owner to pay the amount for the damages. Compensation should be made by the owner only, because the owner is a rich person. He has got deep pockets and he is getting profits out of all the workers. He is a rich person compared to the employee. So the court directs the employer only to take that liability. Then the employer can deduct money from his salary of the employee, or he can sue the employee also to get that money, what he has compensated to the third party. That way only it will be there. So the employer did not do anything wrong. It is the duty of the employee to train the employee to behave to work in such a way that the customers should not be affected. So the employer should always keep the employees in order. He should very often give advice, conduct meetings, give the training properly, so that the employees will not do anything wrong. They will do everything for the customer's satisfaction. If any one of the employees does something wrong, so the employer is also liable for the damage. That's all. This is called vicarious liability. Thank you very much.